Counsel, it can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not doing it.
Hello and welcome, guys, to Dr. John Podcast. So, what just happened, guys? On the first day of July, 6 Supreme Court justices signed onto a doctrine that 3 of their colleagues called the end of accountability itself. Trump v. United States didn't tweak the edges of executive authority. It declared that a president operating in his official capacity exists beyond the reach of criminal law. That ruling is now the fault line beneath every courtroom battle.
Like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we go back to Justice Thomas's question, which was, where does that come from? There are amici here who tell us that the founders actually talked about whether to grant
every contempt finding, every whispered threat of retribution from the West Wing. And right now, it's being stress-tested in federal courts across the country, with judges pushing back, legal scholars screaming from the rooftops, and some of the president's own allies beginning to crack open the door they helped build. The question being asked in every one of those courtrooms is the same. Can anyone still say no one is above the law with a straight face?
Immunity to the president. And in fact, they had state constitutions that granted some criminal immunity to governors. And yet they didn't take it up. Instead, they pass an impeachment clause that basically says you can't remove the president from office except by a trial in the Senate, but you can impeach him after. Or you can impose criminal liability. We would be creating a situation in which we would be saying, this is what you're asking us to say, which is that a president is entitled not to make a mistake, but more than that, a president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold, without facing criminal liability.
Your Honor, I would say 3 things in response to that. First, the doctrine that immunity does not turn on the allegedly improper motivation or purpose.
Before we go any further, you need to see the scaffolding the Supreme Court erected, because that framework is the monster hiding in plain sight. The majority carved presidential conduct into 3 distinct buckets, and the contents of those buckets will determine whether future presidents, not just this one, can walk through the fire unscathed. At the very top sits absolute immunity for anything the court dubbed a core constitutional power. We're talking about the primal functions of the executive.
Is something that this court has reaffirmed in at least 9 or 10
That's
cases.
absolute immunity, but qualified immunity does say that whatever act you take has to be within what a reasonable person would do. I'm having a hard time thinking that creating false documents, that submitting false documents, that ordering the assassination of a rival, that accepting a bribe and countless other laws that could be broken for personal gain, that anyone would say that it would be reasonable for a president or any public official to do that?
Your Honor, as this court said very persuasively in Fitzgerald, the allegation that this particular act would be done for an unlawful purpose or was unlawful could be made in every case. And therefore, if that were the doctrine, that the allegation of improper purpose is what deprives the objective acts of their immunity, then the immunity would have no purchase. And that's reflected in many of the other court's cases.
Commanding the armed forces, granting clemency through pardons, recognizing foreign governments, appointing federal officers. According to the 6 justices who signed on, these acts can never, under any circumstances, become the basis for a criminal prosecution. Not if the evidence is overwhelming. Not if the motive is corrupt to the marrow. Never. Period. The ink on that part of the ruling is dry and impermeable. One step down, you find the murky middle presumptive immunity for what the court called other official acts. Here, the president doesn't get a free pass automatically, but he gets an enormous head start. Prosecutors who want to pierce this shield have to show that bringing charges would pose, and I'm quoting the majority now, no dangers of intrusion on the authority and functions of the executive branch. Legal scholars have been tripping over themselves to explain just how impossible that standard is. When any prosecution of an official act can be painted as an intrusion on the executive, the presumption effectively functions as a permanent firewall. Functionally absolute, they call it. And then, down at the bottom, stripped of all protection, sits purely private conduct. Things a president does entirely outside the orbit of his office. That stuff can be prosecuted. But here's the poison pill the court slipped into the fine print. Prosecutors can't use evidence of official acts to prove the private ones. So even when you're gunning for private criminality, the official conduct that surrounds it gets locked away in an evidentiary vault. The scheme becomes nearly impossible to prove without the context that the court just rendered invisible. Now, the dissents that day weren't polite little footnotes. They were air raid sirens dressed up in legal prose. Justice Sotomayor penned words that have since become a rallying cry for everyone terrified about where this is heading. She didn't hint, she didn't suggest, she spelled out the nightmare scenarios with the precision of a prosecutor delivering a closing argument. Under the majority's reasoning, she wrote, "A president who orders the Navy's elite SEAL Team 6 to assassinate a political rival would be immune. Immune. A president who orchestrates a military coup to cling to power? Immune. A president who takes a bribe in exchange for a pardon. Immune, immune, immune." She ended her dissent with 5 words that now echo through every law school lecture hall and federal courtroom in the country. "With fear for our democracy, I dissent." Those are not the ravings of a partisan activist. That is a sitting Supreme Court justice, in a published opinion, telling the nation that the majority just crowned a king. She didn't stop there. She warned that the ruling reshapes the institution of the presidency and makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. And Justice Ketanji Brown Jackson, writing her own separate dissent, piled on with language even more brutal. She declared that the court had effectively carved out a law-free zone around the president. Those exact words, a law-free zone. Not a gray area, not a debatable margin, but an entire region of presidential conduct where criminal statutes simply evaporate. She warned that the long-term consequences were stark and that the ruling removed the risk of unconstrained official lawlessness for one player and one player only on the American political stage, the president. Justice Elena Kagan signed onto both dissents, meaning 3 Supreme Court justices publicly stated that their colleagues had built a sanctuary for criminality at the apex of the federal government. This isn't cable news spin, it's the formal legal record. The reason I'm telling you all this now with urgency dripping from every word is that the warnings Sotomayor and Jackson etched into the dissents have stopped being predictions. They've become a documentary playing out in federal courthouses, in the marble corridors of the Justice Department, and in the offhand admissions of White House insiders who can't seem to stop confirming everything the dissents foretold. The president, back in the Oval Office after winning the election that followed the ruling, has been using the machinery of the federal government in ways that test every seam of the immunity framework. And each test creates a new crack. Consider what's happening at the Department of Justice. The president, through his handpicked loyalists, has pursued criminal prosecutions against political enemies. Names you know, like James Comey and Letitia James. The instrument of that pursuit was a specially installed U.S. attorney named Lindsay Halligan, whose very appointment a federal judge would later find had been rigged. Judge Cameron Curry ruled that the president and his attorney general circumvented vacancy laws to put Halligan in place. The case against James, in particular, got illuminated by an admission so stunning it genuinely belongs in a political thriller. White House Chief of Staff Susie Wiles told Vanity Fair, in words that now sit in the public record, that the James prosecution was the president's retribution. His own Chief of Staff, on the record, confirming that the official machinery of federal law enforcement was being wielded for personal vengeance. That's not a whistleblower leaking in the shadows. That's the inner circle broadcasting the motive. And motive, my friends, is the thread that can unravel even the sturdiest immunity cloak, because vindictive prosecution is itself a constitutional violation that sits outside the protective bubble of the Trump vs. United States framework. The Wiles quote is a grenade with the pin pulled, and it's rolling through every subsequent legal challenge. Meanwhile, in a separate federal courtroom, another judge is staring directly into the abyss of what happens when the executive branch decides court orders are merely suggestions. Judge James Boasberg issued a ruling that halted deportation flights the administration had already put in motion, sending people to a notorious prison in El Salvador. The administration defied him, not in a subtle, legally cute way, but with the engines already running and the planes already in the air. Boasberg responded by finding probable cause for criminal contempt. Probable cause. That's not a wrist slap. That's a federal judge saying there's enough evidence to believe a crime occurred when the administration looked at a judicial command and decided the president's Article 2 powers as commander-in-chief gave them a permission slip to ignore it. The administration's defense leans heavily on the immunity ruling, arguing that deportations are core constitutional functions and therefore untouchable. Boasberg's finding implicitly shreds that argument, setting up a collision course that will force higher courts and eventually, inevitably, the Supreme Court itself to decide whether the Trump vs. United States framework means a president can openly defy federal judges without facing criminal consequences. That question lands like a bomb in the middle of the separation of powers. And then, as if the first two acts weren't dramatic enough, the whole Comey and James prosecution saga collapsed under its own weight. And the president responded by firing his own Attorney General, Pam Bondi, on April 2nd. The personnel move might look like internal housekeeping, but in the context of the immunity framework, it's another stress test. Firing the Attorney General after failed retribution prosecutions. Is that an official personnel decision cloaked in immunity, or is it part of a pattern of corrupt intent that could pierce through the veil? Every one of these real-world events is a live experiment designed to see just how far the law-free zone Justice Jackson described actually extends. And the original criminal case that birthed this entire immunity monster, the January 6th prosecution, painstakingly built by special counsel Jack Smith, got sent back down to the lower courts by the Supreme Court with a vague instruction to sort out which acts were official and which were private. Smith kept investigating. Evidence kept accumulating. But then the election intervened. The president won a second term, and under long-standing federal policy, a sitting president cannot be prosecuted. The case didn't die because a jury found the evidence lacking. It died because the man it targeted won the office that the immunity ruling now shields more completely than ever. The very framework designed to prevent politically motivated prosecutions ended up insulating its chief beneficiary from accountability for the conduct that triggered the prosecution in the first place. Sotomayor and Jackson warned that this exact sequence would unfold. Their foresight has become our reality. Adding to the instability is the fact that the ruling itself was never a unanimous, settled piece of work. The cracks in the majority are visible for anyone willing to look. Justice Amy Coney Barrett, one of the president's own appointees to the court, wrote a partial concurrence and partial dissent that has become a roadmap for future challenges. Barrett agreed with much of the majority's immunity architecture, but broke sharply on the evidence exclusion. She wrote that the majority's restrictions on using official act evidence to prove private crimes go too far. Her words, a Trump appointee giving future litigants a blueprint for how to narrow the ruling. That is not nothing. That is a signal fire that the coalition holding the current framework together is fragile. When the court eventually takes up a case that forces it to clarify these evidentiary boundaries, and such a case is barreling down the pipeline, Barrett's position could be the pivot that peels away the most extreme protections while leaving the core immunity tiers intact. The scholarly response has been a tidal wave of condemnation that transcends the usual ideological trenches. Lawfare published analysis stating that the ruling goes beyond establishing a doctrine of presidential immunity and declares the president effectively above the law. The ACLU called it grave harm to American democracy. NYU Law Forum noted that the framework has been criticized by scholars across the ideological spectrum. Even conservative originalists, who normally champion strong executive authority, have raised alarms that the ruling cannot be squared with the actual constitutional text and historical record. The Constitution doesn't contain explicit immunity language for the president. The founders debated executive accountability obsessively. This historical critique creates space for future justices to narrow the ruling without abandoning their judicial philosophy. The pressure from the legal academy is not a fringe noise. It's a sustained, cross-ideological drumbeat that the court rarely ignores for long. Constitutional law professor Kim Vela, writing in Just Security, warned that the decision will have repercussions for years to come, and not just for Donald Trump. Her warning connects directly to what we're watching in the lower courts right now. Federal judges across the country are struggling to apply the tiers. Every new case involving a Trump-aligned defendant or an executive action that pushes boundaries forces a district judge to make classification calls that the Supreme Court deliberately left vague. Different judges reach different conclusions. Inconsistency breeds appellate disputes. Appellate disputes breed cert petitions to the Supreme Court. The justices who thought they could drop this ruling and walk away are about to discover that the monster they created keeps knocking on their door, demanding to be fed with more guidance. Each knock is an opportunity to narrow, to clarify, to pull back from the brink that Sotomayor and Jackson mapped so vividly. Think about what happens when all these threads converge. The Wiles retribution quote establishes vindictive intent from the innermost circle. The Boasberg contempt finding challenges whether immunity covers defiance of judicial orders. The Curry ruling exposes procedural corruption in installing a loyalist prosecutor. The Bondi firing suggests a pattern of covering tracks when retribution schemes fail. The Barrett concurrence offers a procedural off-ramp for narrowing the evidence exclusion. The scholarly consensus provides intellectual cover for course correction. The lower court confusion generates the procedural vehicle. All of these elements are converging on a single, inevitable moment when the Supreme Court will have to revisit Trump versus United States, not in the abstract, but in the white-hot context of specific criminal conduct testing the boundaries they drew. Now, in the interest of fairness, because I want you to have the full picture, let me acknowledge what defenders of the ruling argue. They say that some form of presidential immunity is necessary for the executive to function without constant legal harassment. They contend that the three-tier structure actually preserves accountability for purely private acts while protecting legitimate governance. They point out that prior administrations of both parties have benefited from analogous immunities. They insist the majority engaged in careful balancing, not partisan favoritism. They suggest critics overstate the practical effects. These are not frivolous points, and I'm not dismissing them. But here's the problem. The warnings Sotomayor and Jackson issued have not remained in the realm of hypotheticals. They have materialized. The retribution admission, the contempt finding, the installation of a loyalist prosecutor through procedural shortcuts, the firing of the Attorney General after prosecutions collapsed. These are not theoretical abuses. They are documented events that track precisely with the scenarios the dissents laid out. The defense asks you to trust that the framework will hold against abuses that are already happening inside it. That's a tough sell when the evidence of those abuses is accumulating in real time. So who benefits from this immunity architecture, and who gets crushed beneath it? The short-term winner is obvious. The president himself gains a structural shield that covers his current term and shapes his post-presidency exposure. Future presidents inherit a precedent that invites expansive use of official powers without personal legal risk. The unitary executive theory gets a doctrinal victory at the highest level. The losers are stacking up fast. The rule of law loses whenever an office holder is placed beyond the reach of criminal accountability. Federal prosecutors lose the tools to investigate and charge presidential misconduct. Ordinary Americans lose the foundational principle that Sotomayor articulated so bluntly, that no man is above the law. State courts lose authority to apply normal legal standards to former presidents in certain contexts. The damage radiates outward in concentric circles. What comes next depends on how the current legal battles resolve and which of the brewing disputes reaches the Supreme Court first. One scenario sees the administration continuing to push the boundaries, generating fresh litigation that forces the justices to narrow specific applications. Another scenario envisions Justice Barrett's evidence exclusion concerns becoming the precise vehicle for carving back the most extreme aspect of the ruling while leaving the core immunity tiers intact. A third possibility involves a future case with facts similar to the original Trump versus United States dispute being granted certiorari to clarify or revise the doctrine. And of course, the framework could simply calcify into a permanent feature of American constitutional law exploited by presidents of both parties for generations. The direction we take depends on the courage of judges, the persistence of prosecutors, and the willingness of the public to demand that the law-free zone Jackson described be closed. I want to leave you with the central question that this entire saga forces us to confront, because at its heart, this isn't really about legal technicalities or procedural maneuvering. It's about the soul of democratic government. American constitutionalism has always rested on a single luminous principle, that the people who govern are not above the laws they enforce. Previous Supreme Court rulings, even those that expanded executive power, generally preserved that line. Trump versus United States crossed it. The dissents of Sotomayor, Kagan, and Jackson are not just legal arguments. They are a warning inscribed in the permanent record that a majority of the court has created a framework where the president can use official powers as a shield for criminality, with vanishingly few avenues for accountability. The events unfolding since the ruling, the retribution schemes, the defiance of judges, the procedural manipulation of prosecutorial appointments, are not accidents. They are the predictable harvest of a seed the court planted. The framework is unstable not because critics are loud, but because its internal logic is producing consequences that even one of its original architects, Justice Barrett, could not fully stomach. Do we want a country where ordering an assassination through official channels is immunized from prosecution, where taking a bribe for a pardon finds shelter in the very document designed to prevent tyranny, where defying a federal judge becomes a core constitutional power beyond judicial review? Or do we want to fight back through every legal vehicle available, narrowing this ruling until the principle that no one is above the law is restored to its rightful place? The documented crisis of the Trump versus United States immunity framework, rooted in the court's own opinion, the dissents, the scholarly condemnation, and the real-world testing across federal courtrooms, demands that we stop pretending this is partisan hyperbole. This is the legal fight of the era, and the outcome will define whether American presidents remain accountable to the people or become the kings the founders bled to overthrow. The evidence is on the record, the warnings have been validated, and the battle to reclaim the rule of law is happening right now, in courtrooms where judges are finally pushing back.